Friends, breaking news, unless, of course, you're hearing about this later, in which it's old news. But in this particular case, the Supreme Court has done it yet again, and I'm sure you're going to love this one. Those of us who love liberty and the like are taking this to account. Listen to me very, very carefully. The Supreme Court ruled in a 6-3 vote in favor of the Biden administration in a landmark case. Well, I think we're using the word landmark a little bit too much. I don't know if it's really landmark, but in any event, in a landmark case that deals with the subject matter of whether the government involvement in social media censorship extended impermissibly in this case. And the court found that the plaintiffs lacked the standing to sue. Translation, they punted. Why do they do this? Why do you take the case and say, oh, thank you, we're going to take the case. Oh, by the way, you shouldn't have brought this case in the first place. We could have told you that before. They did this in the New Dow case years ago regarding the pledge. Remember that one, the Great Pledge of Allegiance? Justice Barrett wrote the majority opinion, asserting and stating in effect that 2 states and 5 social media users do not have standing to contest or object to the level of coordination and involvement and interference between government agencies and nonprofits and tech platforms in restricting, in a sense, content on social media. The majority opinion wrote, quote, "We begin and end with standing. At this stage, neither the individual nor the state plaintiffs have established standing to seek an injunction against any defendant. We, therefore, lack jurisdiction to reach the merits of the dispute." Thanks, and have a nice day. Now the landmark, let's say that again, the landmark case, Murthy against Missouri, Murthy. This is the, quote, content moderation case, and it came from a lawsuit by Missouri and Louisiana against the Biden administration over federal agencies working, in essence, and interfering, in effect, with social media platforms and the like and third-party nonprofits to censor conservatives and the conservative voice online. Now, last July, a district court ruled, in effect, that federal agencies could not communicate with social media companies or nonprofits with the purpose and for the purpose of coercing and intimidating them into restricting your free speech, your alleged free speech. I think it was the Fifth Circuit ruled they partially upheld the injunction then, last fall, and found that multiple federal agencies violated the First Amendment. Remember that? It was a great opinion. The judge just went berserk. This was incredible. This is what Justice Barrett said about the Fifth Circuit ruling. Quote, "This evidence indicates that the platforms had independent incentives to moderate content and often exercise their own judgment. To be sure, the record reflects that the government defendants played a role in at least some of the platform's moderation choices. But the Fifth Circuit, by attributing every platform decision, at least in part, to the defendants, glossed over complexities in the evidence." Justice Alito, my new favorite, issued a scathing dissent, accusing the nation's highest court, SCOTUS, of failing yet again to uphold its manifest duty on such an important free speech case. Quote, Alito said, quote, "What the officials did in this case was more subtle than the ham-handed censorship found to be unconstitutional in Vullo, Vullo. But it was no less coercive. And because of the perpetrators' high positions, it was even more dangerous. It was blatantly unconstitutional. And the country may come to regret the court's failure to say so." Further, quote, "If a coercive campaign is carried out with enough sophistication, it may get by. That is not a message this court should send." I love it. And by the way, in a wonderful piece, in a wonderful review and an admiration by, which I refer to you by one James Lynch in National Review, it's an excellent piece, and I will put the citation there for you to read as well. But 3 doctors apparently opposed to restrictive coronavirus lockdowns. Doctors Jay Bhattacharya, I know I'm mispronouncing it, Martin Kuldroff, and Aaron Kheriaty, 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 were plaintiffs in the case. They were represented by the New Civil Liberties Alliance, the NCLA, which is a legal group that seeks to reduce the size of federal government. Translation, on our side. The NCLA Senior Litigation Counsel, John Vecchione, which means big old guy, said in a statement, quote, "The government can press third parties to silence you, but the Supreme Court will not find you have standing to complain about it, absent them referring to you by name, apparently. This is a bad day for the First Amendment, and I concur." Remember, documents that were obtained and gathered and culled and collated during the litigation appear to show the White House officials and employees at multiple federal agencies pressuring Twitter and Facebook into limiting and restricting the distribution of scientific opinions that ran counter to official COVID guidance. Translation, Fauci. Some of the opinions posted by credentialed and legitimate public health experts and doctors ended up being accurate, such as when Bhattacharya and others questioned the wisdom of stay-at-home orders. In fact, remember, what's his name, Fauci even said, I made a mistake with that one. Or remember when they argued that school crackdowns, or lockdowns rather, were unnecessary. Well, additional government censorship attempts and efforts and involvement came to light thanks to the, quote, Twitter files. Thank you, Elon. Which, of course, as you recall, it was a series of internal documents released by a group of independent journalists following, was it Taibbi and Barry Weiss? Wasn't that one? I believe. Following Elon Musk's purchase of Twitter, now it's X. Upon purchasing Twitter, Musk fired the platform's top executives and removed speech limitations. Thank you! That had long been the subject of conservative and civil liberties speculation and the like, and objection like from you and me. Online censorship became an important issue and still is, in my book, for conservatives following Twitter and Facebook's decision to censor the New York Post reporting on contents of Hunter Biden's laptop ahead of the 2020 presidential election. In fact, recently, one of the first things the FBI said was, yep, that's his all right. That's his. They validated it. And the New York Post sought to Twitter then, bounce you if you were to even reference that. Twitter's internal deliberations regarding the Post violated its hacked materials policy, and they said were a cornerstone of the Twitter files revelations. As you recall, in Hunter Biden's criminal trial, the FBI Special Agent Erica Jensen, a 20-year veteran of the Bureau, a veritable latter-day Ephraim Zimbalist, gave detailed and exquisitely beautiful testimony for the prosecution on exactly how federal investigators verified the laptop. FBI agents and agents of the government cross-referenced the laptop serial number with Biden's iCloud backups to verify the data, and an FBI technician extracted data from the computer once it was verified. It was his! It was his! But according to Twitter, then they said, no, that's we know better. House Republicans have made the coordination and interference, and if you ask me, conspiracy between social media platforms, misinformation, nonprofits, and these agencies as a mainstay, a hallmark of investigative efforts. The House Judiciary Committee and its weaponizing subcommittee have released multiple plenary reports on the efforts by Homeland Security, FBI, and other agencies to work with nonprofits to pressure tech companies into holding back and limiting and curtailing certain forms of speech. In fact, the reports are based on internal documents obtained primarily via and through the power of the subpoena. The Stanford Internet Observatory, which is one of the nonprofits frequently cited in the congressional reports, is shutting down because of the legal fees attached to investigations and lawsuits. 2 years ago, the DHS briefly formed a, quote, listen to this, a, quote, disinformation governance board to streamline its process of monitoring supposed, quote, disinformation online. Don't forget, not misinformation, not disinformation, that information. Disinformation. And the panel was quickly shuttered. Remember this one? After that loopy executive director Nina Jankowicz's history of partisan and false claims. Plus, she's a nut. Remember her? She was dancing and, they don't even care how they do it. Government officials and big shots and panjandrums working with social media platforms to restrict certain forms and frameworks of speech has the potential to influence the 2024 elections, as you can imagine, and shift public opinion on hot-button and critical issues. Left-wing commie organizations have expressed concerns over the lack of perceived, quote, disinformation. Disinformation means the truth. That's the irony. So they've expressed these concerns and worries over the lack of perceived misinformation monitoring. We got to monitor this. Who? We are, of course. And the potential for false claims, they say, to spread about the 2024 presidential elections. So, my friends, I don't know how to say this again, but the Supreme Court did it. They punted. But the issue is coming back. And it's going to be addressed. And it's a fascinating issue. Because what you're doing is you're having the federal government using social media platforms as proxies. Proxies, do you hear me? And we can't allow that. What do you think, my friends? Subscribe herein to Lionel Legal. This is my ancillary, my supplemental website, my website, my YouTube, which corresponds to Lionel Nation. Lionel Legal. And dear friends, I ask you to comment. Comment bravely as you see fit.